In the previous section, we explored the principle of good faith and fair dealing, and how it requires honesty, fairness, and cooperation throughout every stage of a real estate transaction. That concept ensures that each party fulfills the spirit and purpose of the agreement, not just its written terms. Building on that foundation, we now turn to another essential concept in Arizona contract law: the assignment of contracts. Contract assignment allows one party to transfer their rights and obligations under a contract to another party. But this process must be done lawfully, transparently, and in good faith to remain valid and enforceable. An assignment in real estate occurs when a buyer, known as the assigner, transfers their contractual interest in a property to another buyer, known as the assignee, before closing. This means that the assignee steps into the assigner's position and assumes their contractual rights and obligations with the seller. The original contract remains intact, but the party entitled to perform and receive benefits changes. Assignments are common in Arizona transactions involving investors, wholesaling, or development projects, but they require careful adherence to contract terms, statutory rules, and ethical standards to prevent misrepresentation or disputes. Under Arizona law, contract rights are generally assignable, unless the contract specifically prohibits assignment or the nature of the contract makes assignment inappropriate. The general rule, established through case law and contract doctrine, is that any contract involving property or money can be assigned unless the agreement involves personal services or a unique relationship of trust. ARS paragraph 472210, though focused on commercial contracts, reflects this broader principle. Rights under a contract may be assigned unless such assignment would materially change the duty of the other party or increase their risk. In real estate, the seller must consent to assignment only if the contract explicitly requires such approval. Most Arizona purchase contracts, including the Arizona Association of Realtors, residential resale real estate purchase contract, allow assignment unless the parties specify otherwise. If the buyer intends to assign the contract, this intent should be stated clearly in the purchase offer. For example, a buyer might write John Smith and/or assigns in the buyer's section of the contract. This phrase signals to the seller that the buyer may transfer the contract to another party prior to closing. However, the use of and/or assigns does not automatically release the original buyer from liability. Unless the seller agrees in writing to a novation, a complete substitution of one party for another, the original buyer remains legally responsible for performance under the contract, including earnest money and closing obligations. For instance, suppose an investor places a property under contract for $400,000 with the intent to assign it to another buyer for $420,000. The investor signs as ABC Investments and/or assigns. Once the new buyer is identified, the investor executes an assignment of contract agreement, transferring all rights and obligations to the assignee. The seller still receives $400,000 at closing, while the investor collects a $20,000 assignment fee. If, however, the assignee fails to close and no novation was executed, the original investor remains liable for breach of contract. This example demonstrates why understanding the distinction between assignment and novation is critical in Arizona real estate practice. Assignments must also comply with the duty of good faith and fair dealing discussed earlier. Arizona courts have held that concealment of an intent to assign or misleading a seller about the nature of the transaction can constitute fraud or bad faith. In Mohammed v. Robbins, Arizona Apps 1975, the court emphasized that real estate transactions must be conducted transparently, and a party's actions that mislead another about who will ultimately purchase the property may invalidate the contract. Similarly, brokers and licensees who facilitate assignments must fully disclose all material facts regarding the transaction and any compensation received, as required by Commissioner's Rule R428MO1A and B. The process of assignment in Arizona typically involves the following steps. First, the assigner and assignee execute an assignment of contract agreement, a separate written document outlining the transfer of rights and obligations, the assignment fee, if any, and acknowledgement by both parties. Second, the escrow officer must be notified of the assignment so that closing documents and title records reflect the new buyer. Third, if the original contract requires the seller's consent to assignment, written authorization must be obtained before the transfer occurs. Finally, the assignment must be performed in accordance with any deadlines or contingencies in the original purchase contract. Failure to do so could result in breach or cancellation. Real estate licensees involved in assignment transactions must exercise particular caution. The Arizona Department of Real Estate, ADRA-E, has issued guidance reminding brokers that advertising properties under contract for resale without ownership interest can violate advertising and disclosure rules. Licensees must disclose that they hold an equitable interest in the property rather than legal ownership, and all marketing must clearly identify the nature of that interest. Misleading advertising or failing to disclose the role of an assigner could result in disciplinary action under ARS. Paragraph 32 to 153. Discussion. What is the primary difference between an assignment and a novation in a real estate contract? Answer. An assignment transfers contractual rights and obligations to another party but does not release the original buyer from liability, while a novation substitutes a new party entirely, releasing the original buyer from further obligation. Why must buyers act transparently when assigning a contract? Answer. Because concealing the intent to assign or misleading a seller about the ultimate purchaser violates the duty of good faith and fair dealing and can constitute misrepresentation. When is seller consent required for assignment? Answer. When the purchase contract explicitly states that the seller must approve any transfer, or when the assignment materially changes the seller's obligations or risk. Review summary. Contract assignment in Arizona allows a buyer to transfer their interest in a property to another party before closing, provided the contract permits it and the process is handled with full disclosure and good faith. The assigner retains liability unless the seller agrees to a novation, which completely substitutes the assignee. Assignments must be documented through a written agreement, disclosed to escrow, and performed within contractual timeframes. Arizona case law, such as Muhammad v. Robbins, reinforces that honesty and transparency are essential in assignment transactions, as failure to disclose material facts may constitute fraud. Brokers must also comply with disclosure and advertising regulations when facilitating assignments. When properly executed, assignments provide flexibility in real estate investing, while maintaining the integrity and enforceability of Arizona contracts.